Good afternoon. Good morning, good afternoon, ladies and gentlemen. I am Ahmed Barakat. I am the senior partner and head of litigation department at ASAR Ruwayeh Partners, a law firm. We are very pleased to sponsor this webinar in collaboration with the Cairo Regional Centre for International Commercial Arbitration, also known as CRCICA. This webinar promises a very sumptuous intellectual meal because it addresses a very timely, practical, and important issue, namely the application of the Expedited Arbitration Rules. Some of you will know that the need for expedited rules has emerged as a result of the concerns shown by many arbitration practitioners and companies about the lengthy process involved in arbitration hearings, the high cost involved in running complex arbitration cases. And therefore, it was felt that it was very necessary to introduce expedited arbitration rules as a means of curing these concerns, i.e., the purpose of the expedited arbitration rules is to streamline the arbitration process in a time and cost-effective manner and to speed up the efficient resolution of disputes while maintaining and not compromising the important aspects of fairness and due process. So the balance is very, very important. Now, the expedited arbitration rules as a concept have actually been adopted by many international arbitration centers. So you have expedited arbitration rules adopted by the ICC, by CIAC, by the Swiss Arbitration Association, by the Hong Kong Arbitration Association, and so on and so forth. The model, however, that has been chosen by CRCICA, as a model for developing their own expedited arbitration rules was the UNCITRAL, the United Nations Commission on International Trade Law. They came up with their expedited arbitration rules back in 2021. And the center used those rules as a starting point for devising their own independent rules that maintains the independent character and the characteristics, and the corporate culture of CRCICA as an independent arbitration institution. Therefore, expedited arbitration rules is a very, very important topic, and I have the great pleasure of having Dr. Ismail Selim, who is the CRCICA's director. Dr. Selim has been the director for almost 8 years. I hope I'm not screwing up the number, Dr. Ismail. Has been the director for 8 years, as I mentioned. And Dr. Selim is an accomplished and very well-renowned arbitrator with a long and outstanding experience in the area of international arbitration. Under his auspices, and I would admit as an eyewitness, that the center has actually advanced very much in terms of stature and profile because of the good leadership and the strenuous efforts exercised by Dr. Ismail in promoting CRCICA. Dr. Ismail also is the president of IFCA, which is an association of most of the international arbitration institutions, including some of the renowned arbitration centers like ICC, LCIA, and so on and so on forth. So Dr. Ismail, is wearing many hats today, in making this presentation. Most primarily, obviously, his capacity as the director of CRCICA, as I mentioned. Dr. Ismail, as well, I got to admit that, notwithstanding the importance of the subject matter, the real cherry on top of the cake is the presence of Dr. Ismail with us. We are, very much looking forward to his presentation. And once again, we are very proud at ASAR Ruwayeh Law Firm to host that webinar in collaboration with CRCICA and in the presence of Dr. Ismail, who is, above all, is a very decent human being at the core. I think that's probably because of his upbringing at French schools. And I'm not sure whether I'm getting that right or not, Dr. Ismail, but I know you are fluent in French. Whether that is a result of French education or otherwise, I mean, maybe you can shed some light on that. But I've known the man for a number of years now, a very decent individual. I'm proud to call him my friend. And without further ado, I want to pass on, the mic to Dr. Ismail. The floor is all yours, sir.
Thank you very much, Mr. Ahmed Barakat, and thank you so much for hosting this event and for moderating it and for the very kind introduction and all what you have said about CRCICA and about myself. I'm very touched and I'm very thankful to you. I'm also proud that you are a member of the Board of Trustees of the CRCICA, and you are the model of a very successful Egyptian working in Kuwait since many years and an outstanding lawyer. And we are all proud of what you have achieved with ASAR Law Firm, which is definitely one of the leading law firms in the GCC region. Good morning, ladies and gentlemen. Thank you very much for your time and for being with us to attend this presentation of the CRCICA Expedited Rules. I will now share with you a PowerPoint presentation. Before just starting, I will mention about the French language.
So very important. Hopefully, the comments are not going to be in French.
Yes, also this is required by Mr. Ahmed Barakat, so I will respond to this. I was lucky and I am proud of my late father. My late father was a diplomat and a brilliant ambassador and a very elegant and brilliant ambassador. So he was the Consulate General of Egypt in Geneva, and then the Ambassador of Egypt in Côte d'Ivoire, and then he was the Ambassador of Egypt in China. So as a child, I have lived with my father, and I think I was very privileged to have such a childhood because I have been exposed to different cultures. And this exposure to different cultures has permitted me to be very open-minded and having a facility to deal in a very tolerant manner with various cultures. So I've spent my first 4 years of my childhood in Geneva, and I was watching the Swiss and French TVs. So I was, as a child, I have a single recording, so that remains since I was 2 years old. And I had really the voice of a French child with no accent. And then I moved to Côte d'Ivoire, where I was in a French school. And also in China, I was in a French school. And when my father retired, I was back to the Collège de la Sainte Famille Jésuite, which is also considered in Egypt one of the best French schools, if not the best one at that time at least. So this was my exposure to the French language. And then my education, my postgraduate education was also in France. I graduated from the École Nationale d'Administration, which is, I got from there a master's in public administration. And it is the same school from which President Emmanuel Macron and François Hollande and most of the French presidents like Jacques Chirac, all the French presidents, François Mitterrand, Valéry Giscard d'Estaing, all the French presidents graduated from the École Nationale d'Administration except Nicolas Sarkozy. I have also been exposed to the Chinese Mandarin as a child, so I can still speak some little Mandarin, and I try when I travel to China to practice some Mandarin, but unfortunately I did not study Chinese when I was a child, and I think this was a great missed opportunity after what we see with the expansion of China in the economy of the world. So that was...
I'm sorry, I feel very envious. You know, I mean, now with upbringing for the first few years in your life in Geneva, it's not a bad place, you know, to be brought up. I mean, with everything you said about your French upbringing, I think you should consider running for the next round of the presidential elections in France. You know? Graduating from the same school like most of the French president, very, very impressive. I'm going to put to the side your comments about Mandarin because that opens, you know, a Pandora's box. So we might as well, you know, I mean, put it to the side for now. But thank you for that very informative introduction.
Thank you so much. So now let's start with the arbitration. So I just wanted to make these comments about the early years of my life, which I think they have affected me. But now I would like to share with you a PowerPoint. First, I will start with a presentation, a general presentation of CRCICA, and then it will be followed by a focus on its expedited rules.
Please.
So I will get some help with from the IT.
We can't live without them, Dr. Ismail. I have my help around as well.
Although I am familiar with Zoom much more than Teams, but I always prefer in these situations to solely focus on the presentation. So you will see first the logo of the CRCICA at the left upper side of the slides. That's our logo. About CRCICA, CRCICA is, or the Cairo Regional Centre for International Commercial Arbitration. And I usually focus on the use of the acronym CRCICA rather than Cairo Center, because CRCICA is a truly international arbitration center. It has been established as an international organization bound by a headquarters agreement. So our parent organization is ALCO. ALCO is the Asian African Legal Consultative Organization, comprised of 48 member states, all from Africa and Asia. And I believe Kuwait is a member of ALCO. It's a member state of ALCO. ALCO has been established after the Bandung conference that has established the non-aligned movement. And at that time, the recently decolonized Asian countries, followed by African countries, following the end of the colonial era, they needed a legal advisor, an organization that would provide legal advice in international law, in public international law, especially that these countries, many of them were new members to the United Nations. So until now, these countries do rely on the legal advice provided by our parent organization, ALCO, in all matters relating to public international law. Then in the 1970s, ALCO realized that there is a lack of expertise in international arbitration within its member states. For the example of a country like Egypt or many other countries, having a lot of brilliant lawyers, brilliant scholars, but very little expertise in international arbitration. I'm talking about the era of the 70s. So the idea was to establish two arbitration centers, one in Asia and one in Africa, so that the administration of arbitral procedures is not limited and exclusive to arbitration centers located in Europe and in America, so that the Asian and African countries do contribute in administrating arbitration proceedings on their soil, and also especially with regard to the contracts and projects executed in Africa and in Asia. So in 1978, during the ALCO yearly meeting in Doha, that was the Doha session, it has been decided to establish two arbitration centers, one in Kuala Lumpur and one in Cairo. The arbitration center in Kuala Lumpur was established in October 1978, and it's now called the Asian International Arbitration Center in Kuala Lumpur. And the second center was to be established 3 months later, was the Cairo. It was not named Cairo at the time, it was named the Regional Center of International Commercial Arbitration in Cairo. and this was in 1979, January 1979. The most important part of this slide is, have a look at the right side. In 1987, the headquarters agreement that was signed again, so another agreement. So there was the first agreement between ALCO and the Arab Republic of Egypt to establish the center as a temporary center. And then in 1987, it was decided that the center, after its success, starting from its early years of establishment, to convert it into a permanent center. And this permanent center would be endowed with diplomatic immunities and privileges, ensuring its independence vis-a-vis the host state. So CRCICA has a headquarters agreement. Likewise, any international organization working in not only on the Egyptian soil, but any international organization enjoys the privileges and diplomatic immunities provided for in its headquarter agreement with the host state. So, for example, CRCICA enjoys an immunity against jurisdiction, an immunity against enforcement. And this is very important because losing party will not find a parallel way to the annulment proceedings, because usually the annulment proceedings do not succeed. It's very unlikely that an award is set aside. So sometimes, unfortunately, there are losing parties who can decide to sue the center or to sue the arbitrators. It doesn't happen very frequently, but it happens. So that's why the center is endowed with immunity against jurisdiction, immunity against enforcement, and also provisions that ensure that its premises are immune from any intervention from the host state. So, for example, a court bailiff or any authority of the host state cannot enter the premises of the center without its permission. The center is treated like any other diplomatic mission or international organization operating in Egypt or operating elsewhere, because these provisions that we find in the headquarters agreement are uniform, and you can find them. It's part of customary international law, or to be more precise, the international treaties that are signed between the international organizations and the host states to permit the international organization to operate independently and to achieve their missions. So this is the headquarters agreement. Then the board of trustees of the CRCICA. One other important aspect of our independence is that the director of the center and the extension of his or her term is decided by the board of trustees of the center. And you will see the variety of nationalities constituting the board of trustees of the center. The bylaws of the board of trustees provide that 80% of the members of the board of trustees must be either Asian or African. So there are 80% are Afro-Asians from the members, and 20% are, as you can see, we have members from France, from Germany, from Spain, from Russia, and so on. So there is a blend between Afro-Asians and Europeans, and we can also, in previous boards, we had also American members of this board of trustees. And the board of trustees meets the director several times during the year, at least once, but usually more. The director of the center would present to the board of trustees the financial statements of the center and the general activity of the center and the business plan or the business plan for the year following, as well as any strategic decision to be taken by the center is taken after consulting the board of trustees, while the day-to-day management is entrusted to the director without any interference from the board of trustees. The board of trustees was presided by the late Dr. Nabil El Arabi, the former Secretary General of the Arab League and famous international arbitrator. Today, the board of trustees is presided by His Excellency Mr. Nabil Fahmy, former Minister of Foreign Affairs of Egypt from 2013 to 2014. The chairman of the Board of Trustees must be Egyptian, while the vice chairman, one is African, here Dr. Gaston Kinfak from Cameroon, and another is Asian, Professor Nasib Ziadeh from Lebanon and Chile. Then we also have the advisory committee. The advisory committee plays an important role in the cases administered by CRCICA. The advisory committee is presided by Mr. Craig Tevendale, who is the head of the international arbitration practice of Herbert Smith Freehills London office. The advisory committee exercises several functions under the rules, including but not limited to deciding on challenges against arbitrators, deciding on requests to remove arbitrators, deciding on requests to consolidate parallel proceedings, deciding on requests not to proceed in case the center does not have prima facie jurisdiction over the case, requests to derogate from the scale of fees of the arbitrators, a request to permit the arbitral tribunal to proceed on a truncated basis. So these are the various functions of the advisory committee. The advisory committee can meet at any time to take decisions, but would usually also meet every 3 months to discuss also other issues submitted to it for consultation by the director of the center. For example, we are going to issue very soon a set of practice notes that would show the user and clarify to the user how certain provisions of the new CRCICA rules are applied. You will see that the composition also of the advisory committee is very diverse, and the advisory committee is recognized by independent reports that the level of the reasoning that it provides to the users, because when there is a challenge against an arbitrator, the reasons for accepting or dismissing the challenge are delivered to the users. And the quality of these reasons is known as, and I'm quoting, corresponding to best international practice. The next slide, also I would like to present my dear colleague, the Deputy Director of the CRCICA and the Director-elect. So she has been chosen by the Board of Trustees that starting from January 2026, she will be the next director of the CRCICA. So she has been working for 10 years with the CRCICA, but before joining CRCICA, she was one of the leading members of the arbitration practice of Dr. Karim Hafiz. So of course, you know Hafiz Law Firm. It was one of the leading practice at that time in the Middle East. She has served as counsel in many complex arbitration cases under ICSID, ICC, CRCICA. She served as arbitrator also under BCDR rules and served as counsel under DIAC rules as well. Before joining Hafiz, she was serving in the Egyptian Ministry of Justice and supporting the international firms who were handling the investor state ICSID cases filed against Egypt. And you know very well, Egypt is the third most sued country before ICSID, with its 100 BITs signed and 76 of them are have been ratified. So that is why Egypt is exposed to investor state arbitrations and has never withdrawn from the Washington Convention. Also, Dr. Dalia is a scholar and she teaches international arbitration and she holds advanced, so she teaches international arbitration in the AUC, in the American University in Cairo. She's an adjunct professor at the American University in Cairo and a lecturer, and very soon professor at the Zakazek University in Egypt. She also holds advanced degrees in law from prestigious universities such as Paris 1, Panthéon-Sorbonne, and Paris 2, Panthéon-Assas, which are the most renowned universities in France. Recognition and awards of the CRCICA So I was talking about neutral external reports praising the work that has been done by CRCICA. So for example, the African Development Bank has issued 2 reports. You can find them on internet, 2 independent reports on CRCICA. The first one was in 2014, and the second one was issued in 2022. So if you want to know how an arbitral institution can be evaluated and assessed, one of these ways to do it is how Lalive Law Firm, because it was Lalive Law Firm that has done this and has written this assessment report based on a mandate from the African Development Bank. So there are many analyzed criteria. So modern set of rules, the criteria is fulfilled. Arbitration friendly environment at the seat of the center, that is also fulfilled. The good language skills of the employees. And I have introduced the French language as a third working language. The CRCICA has been operating for decades in English and Arabic. When I took the helm of the CRCICA, and as mentioned by Mr. Barakat, because of my, let's say, because I have studied in France and because I think I'm keen on promoting the French language whenever it is necessary for the users. I have to admit that English is, of course, much more widespread. And even our French users, so the French companies that use CRCICA, usually their arbitrations are in English or even in Arabic. But it happens from time to time when the 2 parties to the contract that is referred to arbitration, subject of the dispute that is referred to arbitration, when the 2 parties are Francophone parties, and this was the example of a case that we have administered in French in 2022. It was a case between an African organization and a Moroccan party. So they were both Francophone. So they chose the CRCICA rules and the French as the language of arbitration. And we had from both sides a French firm against a Swiss firm and a Belgian sole arbitrator. But what I was, and I am proud of, is how they believe that the way the CRCICA has managed and administered these proceedings in the French language perfectly, as if CRCICA was based in a Francophone country. This is because of the language skills of some of our case managers who are extremely fluent in French. The African Development Report in 2014 recommended that CRCICA adds the French language because CRCICA is based in Africa, and North Africa and West Africa contains most of their countries are fluent in French and use the French as the official language. So the French language was introduced as a working language of the center. One of the criteria is also to assess the institution under the African Development Bank report is the neutrality vis-a-vis the host state. If you read this report on internet, you will notice that this report recommends CRCICA for cases filed against the Egyptian government. And that is a reality. The majority, the vast majority of the cases filed against the Egyptian government were won by the private party. So whether this private party was a foreigner or an Egyptian. And this is an evidence of the neutrality of the CRCICA, and the Egyptian state and the Egyptian government has respected for almost 5 decades the independence of the CRCICA, the independence of its director and the independence of its case management and the process of appointing arbitrators in the CRCICA cases involving the Egyptian government. The CRCICA has also administered cases involving other governments in the region, whether these cases were completed with a final award or have been settled in the middle of the proceedings. But I can mention, by way of example, cases filed against the Lebanese government, cases filed against the UAE government, cases filed against the Sudanese government. I'm not saying the government, so the prime minister or the state itself, but sometimes the state itself and sometimes a state-owned entity. It depends whether it was a commercial arbitration case or exceptionally an investor-state dispute. The CRCICA features in dozens of BITs, including BITs where Egypt was not a party thereto. For example, the BIT between Libya and Morocco, and we have also administered cases involving the Libyan government or Libyan state entities, as well as the Morocco as well as a state entity. And Yemen, of course, and state entities from Yemen as well. So I'm indicating this. Yes.
Oh, that is impressive. Sorry for interruption, Dr. Ismail, but that's news to me, actually. The fact that, CRCICA can operate as a dispute resolution forum for investment arbitration, against states and what have you. That is a very, very interesting feature of the work. It's concerning, however, that we are accepting a lot of cases against the Egyptian government. I might have to reconsider my membership, on the board of trustees. I might be getting in hot water,
No.
but it's
it will.
As you said,
sorry, it does not affect
evidence of the neutrality of the center. Sorry for the interruption, but I thought that it is a very, very interesting feature that I was not personally aware of.
Thank you so much. So I'm not saying that it's very frequent that CRCICA administer investor-state disputes. The number of these cases, including those who were not finalized by an award, it's around 4 or 5 cases. But it's a reality, and nothing prevents, of course, that we get more cases. We were also requested to mediate as part of the cooling off period under the bilateral investment treaty between Egypt and Kuwait, for example. But I have to admit that foreign parties, when they sue the Egyptian government or the other governments of the region, when they have the option to go to ICSID, they go to ICSID. So, of course, ICSID is eclipsing CRCICA when it comes to investment state disputes. This is something that it's a reality that I cannot deny. But CRCICA remains an option for many reasons. And even if the case is filed against the Egyptian government, whether it's a commercial arbitration case or an investment arbitration case, it has never been reported that CRCICA would lack neutrality. Sometimes it can be a perception because, of course, an investor who is not an arbitration specialist, the in-house counsels in entities, they are not always arbitration specialists like the external legal counsels and the arbitration arms in law firms or the arbitrators. So, of course, they would prefer to choose an institution that is not located at the host state of the investment. But I wanted to emphasize on this because it has happened in the past. This is not to count the numerous commercial arbitration cases that has been filed against governments under CRCICA rules, governments always from the region so far.
Thank you very much. That's very.
I think this is an important. I think this is an important feature. And if you read this report, the report emphasizes on CRCICA's neutrality, even in cases filed against the host state, state-owned entity. We see it at the end of the PowerPoint, neutral venue in case of communality of origin between one of the parties and the center's host state. Here also the report praises the work done by the case management team. So the report says that the general view that the quality of services provided compared with large international centers like the ICC, the Stockholm Chamber of Commerce, SCC, and the London Court of International Arbitration. And I will tell you simply why. So at CRCICA, every case manager is handling between 20 and 25 cases, not more, never more than 25 cases. That's relatively a low number of cases compared to a case management manager in other leading international or regional arbitration institutions. I hear from my dear colleagues in other arbitration institutions, sometimes the case manager is handling almost 100 of cases at the same time. So if you compare the ratio, that's why every time a new arbitrator or a new counsel who has never experienced CRCICA before praises how responsive our case managers are. They know very well how the rules apply, and they are on top of their cases. And I think one of the very important aspects that makes the difference when we need to notify the respondent with the notice of arbitration, the arbitration request that we call under our rules the notice of arbitration. The effort that is exerted by CRCICA to notify the respondent for the first time of the arbitration case. We notify the respondent in every possible address where we can reach the respondent. This, we need a long talk, but the practice is impressive. We exert all efforts and we reach the respondent at the end. And even if it costs us a lot to notify the respondent in several, because usually respondents or parties, they can sign a contract, there is an address in the contract, but the address changes. So we use all possible means. And if the respondent is based in Egypt, we even if the DHL does not do the work as, so even the DHL, the person does not find the respondent, we send the personal messenger from CRCICA who would go and investigate and find the respondent and notify the respondent. So, and then the parties would get a report on all the attempts to notify the respondent, and so usually the respondent participates. In case the respondent does not participate, the award is secured because the institution has exerted all possible, sometimes in cooperation with claimant, but all possible attempts are done. And we have exercised, and we have a very unique provision after all these efforts have been exerted. As I have explained, and I invite you to read Article 2 of our rules. They explain the process, how we do step by step until the respondent is notified. If after exerting all these efforts, if the respondent has a website, and in this website, or even if it's an email that is held out to the public, through another means, and it means other than a website, but if there is an email that is held out to the public by a party, we can notify after exerting all efforts through DHL and through all the means that I have mentioned. We can notify this party on its email that is held out to the public. And I can give you an example. We were trying to notify a Russian party. And you know, Russia, there are a lot of sanctions and there were difficulties. The DHL does not go there, cannot deliver the mail to Russia because of the sanctions. So we used an email that was delivered to us by a party, and we also used an email that was on the website of the respondent. So through this means, we are securing that the respondent has been duly notified with the proceedings. Now I will move to the next slide, and I wanted just to give you an example. Also, the case managements, they attend the procedural hearings, or the CMC. They attend with the arbitrators the hearing, so the arbitrator can always consult the case manager, and the case manager would be responsive and hands-on the case and on top of the case file. We are on the white list of the GAR. We were the first center in Africa and in the Middle East to be on the white list of the GAR since 2016. And I invite you to read the GAR regional guide, the GAR guide on the regional arbitration institutions on the CRCICA. And since November 2016, the CRCICA is on the white list. The GAR mentioned it is experienced and it is old enough and busy enough to have encountered all the difficult situations at least once, and is generally well managed. Our state-of-the-art facilities, if you do not use our rules, but you need to use the CRCICA hearing facilities, we have a state-of-the-art legal hearing facilities, and cases that are administered by other arbitral institutions or international arbitration ad hoc cases. In these cases, the parties or the arbitrators can approach us to rent our hearing facilities and use our, because we have invested a lot in technology. We have a built-in booth for the interpreters. We have 4 hearing rooms. The small hearing rooms can also be used as breakout rooms in addition to the breakout rooms. And we have a very dedicated team. And we also, for the Opus Magnum equipments, etc., we can coach and help with the custom clearance. Of course, there is a custom clearance agent, but we also help and finish the administrative tasks for that. Also, there are more than 70 nationalities that can get the visa to Egypt upon arrival. There are direct flights to Egypt from many countries. So also the cost is very reasonable compared to holding hearings in other countries of the region or holding the hearings in a hotel. These are the state-of-the-art hearing facilities. If the case is administered by CRCICA or under CRCICA rules, the use of our hearing facilities is for free because it is included in the admin fees of the center. Of course, and we also are present when the hearings are held virtually. And during the COVID time, our users felt that we were really very close to them and guiding them how to streamline the arbitration process during this difficult time of the COVID. During this difficult time of the COVID, the parties were regularly receiving guidelines from the CRCICA how to navigate through this difficult period. Our awards are published. So if you want to have an idea about the quality of the award rendered under CRCICA, of course, they are published, but they are anonymized, they are redacted, or they are pseudonymized. You will find at Kluwer, you will find our awards at Jus Mundi, at our Journal of Arab Arbitration excerpts from our arbitral awards, sometimes also at the international journal that is issued by Dr. Abdelhamid Al-Ahdab. So our awards, you can find them there. Also, we publish and we contribute to GAR, so the Middle Eastern and African Arbitration Review 2019, and also 2024 and 2025, you will find our article on our new rules. So the CRCICA, overview of the CRCICA and overview of the CRCICA new rules of 2024. In the ICA yearbook as well, you will find some awards issued by the CRCICA and published there. I will now take you quickly through the CRCICA's caseload. So this is, for example, the year 2017 to the year 2021. During this was my first term as director. During that period, we have registered 374 cases, and the leading sector or industry was construction. 24% of the cases were construction cases. And other sectors as well, 13% oil and gas, 6.5% tourism and hospitality, 7.5% corporate restructuring, 6.4% media and entertainment, and 5.3% real estate development. And during this period of time, we had parties from 132 non-Egyptian parties, and I'm only counting the companies that are based abroad. If we count the Egyptian joint stock companies, I did not count here the Egyptian joint stock companies or the Egyptian limited liability companies that are ultimately controlled by foreign shareholders. I did not count them. If I count them, the number would be much greater. And you will notice that every year since 2007, since at least 2021, we had a Kuwaiti party. So in between 2017 and 2021, we had at least one Kuwaiti party, at least. I don't have the exact number. You will find parties during this first 4 years from a variety of European countries, a variety of Asian countries and Arab countries, including Kuwait, even from Africa, so from parties from South Africa, from Sudan, several parties from Sudan, from Tunisia, and from America and the United States specifically, and 100 plus non-Egyptian arbitrators have been appointed during that period. If we move to the next slide, the caseload of 2022. So that's an example of a year. We have registered 83 new cases in 2022, 83 new cases in 2021. Construction always comes on top. And you will see that during that year, we have registered, we had 29 non-Egyptian parties, including also a party from Kuwait. In 2023 as well, same, but we registered only 53 new cases. That was really a drop. It was the worst year during my directorship of the CRCICA, but we had a party from Kuwait that year as well. And then in 2024, we registered 76 new cases, including a case involving a party from Kuwait as well. 15 non-Egyptian arbitrators served on these cases. 2025, the year is starting quite well. Until now, we have registered, here you see on the statistics 17, but this was until a certain date. Now I can tell you we have registered 23 new cases since the beginning of the year. And 5 non-Egyptian parties so far, including from China, and 2 non-Egyptian arbitrators, one from Lebanon, the other from Armenia. But there is an arbitrator from China who has just been appointed. And this is normal because we have registered 2 cases involving Chinese parties this year. One, a Chinese company that is based in China, and another case involving an Egyptian joint stock company, but where all the shareholders are Chinese. And I believe that there will be more Chinese investments in Egypt. We are also very suitable for Russian parties. Last year, we had a Russian party from among the cases registered at CRCICA. And because we are a sanction-free jurisdiction, and there are many aspects regarding the payment of the arbitration costs, etc., that are more flexible and more suitable for Russian parties. So I advise you, if you have Russian clients investing in the region, CRCICA can be very suitable given the sanction-free jurisdiction of Egypt and the legal stance of CRCICA as an international organization. The average sum in dispute in 2025 was relatively high. So it was $4 million, $4 million US dollars, $207,000 US dollars. That's the average sum in dispute in 2025 until 19 March. The average sum in dispute in 2024 was relatively low. It was 1.6 million US dollars. So this year, I think, is expected to be a much better year than the year before. The CRCICA, so of course, I want to clarify that this sum, 25 million US dollars, that's the total sum in dispute in 2024 until 19 March, not throughout the year. If we compare it until 19 March, In 2025, the total sum in dispute is $71 million. So we are comparing for the same period within the same year. CRCICA also has made great strides in ADR. It has issued its mediation rules in 2013. It is holding mediation trainings and accreditation trainings regularly. They can be done online now. And we have registered since 2013 around 30 mediation cases. We have a very good, very strong list of mediators trained by CEDAR, and the training was financed by the World Bank. And usually when the parties accept to participate in the mediation, because sometimes we find the respondent not willing to participate in the mediation, so the claimant would request the mediation to the center to exhaust the multi-tiered dispute resolution step in accordance with the multi-tiered dispute resolution clause, would file the mediation request to the center. Usually when the respondent participates, usually we reach a settlement. If the respondent does not participate, the claimant would have no option then to file an arbitration if the dispute resolution clause comprises a multi-tiered and several pre-arbitral steps, including mediation. The CRCICA also is sometimes chosen to appoint experts. So we will issue soon expert determination rules, but for the time being, you can rely on the mediation rules because they apply to any other forms of ADR. The dispute board also CRCICA has issued in 2021 its own set of dispute board rules. We have received until now 10 requests to appoint dispute board members. And now we see that in the projects funded by the World Bank and other multilateral development banks, whether the project is in Egypt or sometimes in sub-Saharan Africa, the center, the CRCICA, is designated as the appointing authority of the dispute board member. And there will be an expansion. I know that the CRCICA will be introduced in new tenders very soon. The CRCICA, yes.
Sorry for the interruption, Dr. Ismail. I just want to give you, a chance to catch your breath. I know you are suffering with a mild cold. However, you decided to fight it off, to proceed with the webinar. That's very much appreciated. I want to give you a chance to simply, catch your breath. And I would like to simply emphasize, some of the key features, of the strength of CRCICA as a dispute resolution forum, and why it should be seriously considered as an alternative by practitioners, in Kuwait and outside Kuwait, as you quite correctly pointed out. The combination of strength points, including independence of the center, as you mentioned, the neutrality, of the center and the practitioners, at the center, the state-of-the-art facilities provided at the center, the efficient case management, of cases as per the recognition of a number of institutions and publications and so on and so forth, the sophistication and the development of the Egyptian Legal Center, which acts as the sort of backdrop, of the practice of the center, the sort of diversity of practitioners and arbitration specialists who are members of the Board of Trustees and the Advisory Committee, with all the tasks entrusted to the Advisory Committee. All these factors, for me, as an arbitration specialist, I think present a very strong foundation for recommending to our clients, the choice of CRCICA, as an alternative dispute resolution forum. It has to be taken very seriously in consideration in drafting our contracts, in advising our clients. There is a lot of benefits compared, with resorting to other regional institutions. I know that obviously CRCICA is in competition with, some of either the established or the emerging regional centers. But I think you've made a very good case for seriously considering CRCICA, as a forum for dispute resolution. Added to that, the very interesting reference you made today to the possibility of using CRCICA for, investment arbitration. Obviously, I take on board what you said. It's not yet an alternative to resorting to ICSID. That goes without saying, but it's a step in the right direction. I like, and I know I'm aware as an eyewitness, a first-hand eyewitness of your efforts to sort of expand the outreach of CRCICA to China, being, the economic powerhouse that it is right now. And frankly speaking, in this sort of politically volatile environment, the sort of tension between the US and China and what have you, I'm sure the Chinese would be looking for, more neutral, independent, centers. I know you've made, serious efforts to sort of expand the reach of CRCICA in China. My understanding, you probably brought your cold from China. I don't want to scare anybody here. It's not another mutation of COVID or anything, but you've been running around and traveling, extensively, as I understand. And then, the whole idea actually of, reaching out to Russia as well, with all the sort of problems associated with the US sanctions, against Russia and what have you. I mean, that seems to be, an interesting dimension in expanding, the reach of CRCICA. So for me, you've made a very compelling case as to why CRCICA should be seriously considered by, arbitration specialists as an effective and as a viable alternative. With that said, and hopefully you managed to have some sips of your hot drink, I will get back to you again, revert back to you to continue your very interesting, insightful presentation, where I think you're going to get into the sort of meaty, substantive arbitration rules, and then I'm sure you're going to be focusing on, our expedited arbitration rules. Thanks again, Dr. Ismail.
Thank you very much. I know that perhaps I have exceeded a little bit my time, but now I think I have given an introduction on the CRCICA, and I have tried to provide our participants, and I see it's a strong participation. 109 persons are following us on Zoom. I think it's a very good participation, but I endeavored to provide our participants with new information as much as I can. Now I will continue to the next slides, the 2024 arbitration rules. So historically, our rules were almost copy and pasted from the UNCITRAL rules. But that was fine when we amended our rules in 2011. But after the development of arbitration and of institutional arbitration during the last 2 decades, we have decided to amend our rules and not to wait for the UNCITRAL to amend their 2010 rules. So we have introduced new provisions that do not exist in the UNCITRAL rules, such as provisions permitting consolidation of arbitrations, filing a single arbitration and to raise claims arising out of multiple contracts, the disclosure of the existence of a third-party funder, the possibility to request the early dismissal of a claim, the introduction of the emergency arbitrator rules, and we have received requests to appoint an emergency arbitrator, and we were able to very smoothly manage the case and appointing an emergency arbitrator within 24 hours and to have a decision issued in less than 15 days. So the process was efficient, very efficient, given our experience. And we have introduced for the first time expedited arbitration rules. In addition to the possibility to online filing of the notice of arbitration or the urgent application to appoint an emergency arbitrator. So these are options and new provisions that exist under the 2024 rules. The fees of the arbitrators also have been increased. So we are still striking a balance between efficiency, cost effectiveness, and also to ensure that arbitrators are well paid. Still, the CRCICA remains more cost effective than some other institutions. I can say that an arbitrator under CRCICA rules is paid around 80% of what he or she would be paid if serving under the ICC rules for the same amount in dispute. So the fees are about 80% of what you would pay in an ICC case. The administrative fees of the CRCICA would be much lesser than the administrative fees of other arbitral institutions. So the cost effectiveness case is there. And here you can compare in this table different amount in disputes and the fees of a sole arbitrator or a three-member arbitral tribunal. So you will see the increase of the arbitrator's fees and the administrative fees of the center. Now I will focus on the expedited arbitration rules. So if you choose to arbitrate under CRCICA rules, by default, the normal proceedings of the CRCICA would apply. But what if you wish to apply the expedited arbitration rules? You need to opt in. So you need to explicitly mention in the arbitration clause that the parties have chosen the expedited rules of the CRCICA, of the Cairo Regional Centre for International Commercial Arbitration. And I invite you to read the model clause on our website. So our website is new, is modern. It has been revamped 3 years ago. You have all the detailed information and the difference between, so Mr. Ahmed Barakat has mentioned that many arbitral institutions, they have their own set of expedited arbitration rules. So the expedited arbitration rules, they strike a balance between the need for celerity and speed and the preservation of due process at the same time. So the difference between us, the CRCICA expedited rules, and many other institutional arbitration rules, expedited ones, is that their implementation are not related to the amount in dispute. So under the ICC rules, if the dispute, the amount in dispute is less than $3 million, the expedited rules of the ICC would apply. This is not our case because we believe that we should enhance party autonomy. That was the approach taken also by the SCC, the Stockholm Chamber of Commerce, the arbitration institute of the Stockholm Chamber of Commerce. They also have taken the same approach as us, which is the opt-in approach. The UNCITRAL expedited rules of 2021 also adopts the opt-in approach. So you need in your contract to explicitly mention that the CRCICA expedited arbitration rules will apply. Is the cost the same as the standard rules of the CRCICA, arbitration rules of the CRCICA? The answer is no. In order to encourage the parties to select and choose the CRCICA expedited rules, the arbitrator's fees are 20% less than the standard proceedings. What kind of contracts, from your point of view, should use the parties of these contracts should select the expedited rules? One of these, so whenever you believe that the dispute that will arise from that contract is not going to be complex, will not require many appointment of many experts and many witnesses, where the quantum that is going to be claimed or most likely going to be claimed is a fixed quantum, a fixed obligation, not a claim that would require that the tribunal would have a lot of discretion in order to determine what amount of dispute it is going to award. So if you have a direct contract, such as, for example, a settlement agreement, the parties have settled that party A shall pay a certain amount of money to party B. There is no wide discretion to be used by the tribunal. You expect a case based on documents only. So I think in this case, you should use the expedited proceedings and agree on them. For example, a lawyer who has a client, but sometimes the client is new or the transaction is very big, and the lawyer wishes to have an agreement in writing on its fees. You can, and it has been tested, that you agree on the CRCICA expedited rules to apply in case of dispute between the lawyer and its client on the fees. I think that's very suitable. In case you have a construction dispute where all the amounts have been approved by the owner, but will be paid later by the contractor. So the payment certificates have been approved by the engineer. You are not expecting delay analysis. You're not expecting complex quantum surveying, etc. So straightforward construction disputes, you can choose the expedited rules. Straightforward lease agreements, you can choose the expedited rules. Any other sale and purchase, international sales of goods, where you believe that the dispute is relatively straightforward, you can choose the expedited rules. Or where you believe simply that you have a dispute that you wish to have it decided within a time frame of 6 months from the constitution of the arbitral tribunal, or a little bit more than 6 months, because the expected duration of the proceedings, the award should be rendered within 6 months from the constitution of the arbitral tribunal. This period can be extended, so there is a flexibility. And here we have departed from the UNCITRAL expedited rules. The UNCITRAL expedited rules provide for the 6 months and then gives the arbitral tribunal the right to extend the duration for 3 months. And if after 9 months, the arbitral tribunal can still not render its award, it can opt out from the expedited rules to go back to the standard rules of the UNCITRAL. We did not choose this approach. We have chosen, I think, a better approach. The duration is 6 months, and then the tribunal can make an application to the center if it needs an extension of time. Or the parties also can make an application to the center, or the center ex officio may prolong the time limit for rendering the final award if it believes that the 6 months is not sufficient and would give an extension. But whenever there is this time limit, there is a pressure on the tribunal to expeditiously prosecute and render its final award. How the tribunal is constituted, the default rule is that one arbitrator is going to be appointed. And the durations for constituting the arbitral tribunal are abridged. They are reduced. So instead of the 30 days for the two parties to agree on the sole arbitrator, the parties would have 15 days. In case the party exceptionally opt for a 3-member arbitral tribunal, then the time limit of 30 days under the standard proceedings would become 15 days under the expedited rules. There are also other mechanisms to speed up the process. You do not need to file a notice of arbitration and then a statement of claim and then an answer to the notice of arbitration and then a statement of defense. No, everything is combined. So you reduce the rounds of submissions by 1. So you file your notice of arbitration, which is at the same time the statement of claim. And then the respondent would file the answer to the notice of arbitration, which is at the same time the statement of defense. And the notice of arbitration would already comprise a proposal to appoint a sole arbitrator. So if you believe that the nature of the dispute would permit you to reduce the rounds of submissions, that you do not need the first round of arbitration request and answer, and that you can file the statement of claims from the very beginning and file the statement of defense from the very beginning, and then you have an extra round of submissions for the reply and rejoinder after the tribunal is constituted, usually by the sole arbitrator, then this means that the expedited arbitration rules are suitable for that contract. What if the dispute after it occurs is more complex than expected, and you have chosen the expedited rules, and the respondent does not want to opt out from the expedited rules, or one of the party does not wish to opt out from the expedited rules? There is always the flexibility. If the 6-month duration is not enough, the center can extend the time limit. So there is no risk if you made the mistake, you agree on the expedited rules, and then it appears that the dispute is much more complex than what you have expected. Other mechanisms to speed up the process, if there is a challenge against an arbitrator, all the durations are abridged and reduced. So if the standard, the procedure for challenging an arbitrator is under the standard rules, the standard proceedings, the party requesting the recusal of the arbitrator has 15 days to confirm that it wishes to pursue the challenge. Under the expedited rules, the 15 days are abridged and reduced to 7 days. Also, under the standard rules, a tripartite committee from among the members of the advisory committee is composed to decide upon the challenge against the arbitrator. This is not the case under the expedited rules. Only one member of the advisory committee will decide on the challenge in order to ensure that the challenge is decided more expeditiously. Another mechanism to expedite this process is that if you believe that you need a process of production of documents and requests to disclose documents, the expedited rules will not be the most suitable rules. Because if one party requests production of documents and the other party objects to that process, the arbitral tribunal will have the power to reject the inclusion of this process within the procedural timetable. So usually if you choose the expedited rules, you do not expect, it's possible, but it's not the norm. You would not expect that the tribunal will accept the inclusion of a phase between the 2 rounds for the production of documents. And that's the model clause for choosing the expedited rules. And you will see in red that the word expedited must feature in the clause. If you use any other verb that is fit for the purpose, we will consider it as an agreement to apply the expedited rules. So if in Arabic it's called the al-tahkim al-najiz or al-najiz, if you use in Arabic al-tahkim al-muajjal instead of using al-tahkim al-najiz, we will consider that you have chosen the expedited rules. I think one of the advantages of the CRCICA also that we do not only administer cases in English. If you choose to arbitrate in Arabic, I believe that we are the center that has the most and the widest experience in administrating cases in the Arabic language within the Arab region. This is what our statistics mention. 2/3 of our proceedings or 3/4 of our proceedings, it depends on the years, are cases administered in Arabic, including cases between parties from Arab countries and not from the same country. So regional cases, many of them are administered in the Arabic language. But of course, also we have a great expertise in administrating cases in English. And our case managers, as I have mentioned, are fluent and trilingual. And they can administer cases in Arabic and English, and many of them can administer cases in French. That's the model clause if the dispute already exists. So if you want to opt out from the standard proceedings and you wish to opt in to the expedited proceedings, that is also the model clause. All these model clauses, you will find them on our website. Now, I think it's time that I give the floor to Mr. Ahmed Barakat, and if the audience, they have questions, I'm happy to answer them. And thank you very much for your kind attention.
Thank you very much, Dr. Ismail, for this insightful and comprehensive presentation. I think you've enlightened, all of us with regard to, the center position, the center capabilities, and, the regular and the expedited arbitration rules. Very, very helpful indeed. If I may start off, and obviously after that we are going to open the session up for Q&As. But what I've noted is, and I think it is a commendable feature of the expedited arbitration rules, is that there is a large emphasis on party autonomy. In other words, as you mentioned, it's an opt-in sort of process where the parties have to express their desire to resort to the expedited arbitration rules. There could be a possibility of the parties agreeing on 3 arbitrators as opposed to 1. Withdrawal from the application of the expedited rules would have to be done by the express consent of both parties, and so on and so forth. One could argue that obviously party autonomy is the essence of the arbitral process. Arbitration is, a choice of the parties, and therefore, a party autonomy should be emphasized. But is there a bit of a risk that, the emphasis on party autonomy could probably, sort of I don't want to use the word undermine, but could impact the sort of objective of the expedited arbitration rules, that is to streamline the process to ensure a speedy and cost-effective, disposition of the case. You mentioned, in this regard, Dr. Ismail, that there are other institutions like the ICC that adopted, a more sort of aggressive approach, if you wish, where it's an opt-out proceedings as opposed to an opt-in. And you mentioned the fact that if a case value is $3 million or less, then by definition the parties would be going through the expedited arbitration rules. So do you see that maybe there is a bit too much emphasis on party autonomy at the expense of streamlining even the process further in the context of the expedited arbitration rules, under CRCICA's auspices?
Thank you very much. Well, we did not want to, when we had, of course, this thinking when we were drafting the 2024 rules, and whether we limit or we link the implementation of the expedited rules with a certain amount in dispute, but we still decided that we should leave it to the parties. And this does not prevent us from playing our role as an institution to streamline the process, even when the standard proceedings apply. Through the efficient case management, we don't have, for example, the process of the terms of reference, which can be useful, but sometimes can also consume some time. So we still leave it for the parties, and if our users, there is really a request from the users that we link the implementation of the expedited rules, we link it to a certain amount in dispute, then at the next amendment of the rules, this can be considered. But now what we are doing, we want our user to test them. And that's why we're trying to guide our rules, that there are some contracts that I have mentioned, I think they should consider when they are drafting their arbitration clause. If the dispute is expected to be complex, then the standard proceedings is more suitable. If the dispute is not expected to be very complex, I think the expedited proceedings can be a very efficient tool in order to finalize the arbitration within a period of 6 months. Yes, I think party autonomy is a very good practice, or the intervention, the heavy intervention of the institution can also be a very good practice. And it's good for the users. They can have both choices. And we have seen sometimes disputes of a very large amount, but the dispute is not complex at all. So they can have this option of using our expedited rules on an opt-in basis, as I've mentioned.
Thank you very much, Dr. Ismail.
And I want to add that this is in line with our party autonomy approach in appointing arbitrators. Right. So under our rules, the default is that the presiding arbitrator is appointed by the co-arbitrators and not by the center.
Right.
Only if the co-arbitrators fail to appoint the presiding arbitrator, then the center would appoint the presiding arbitrator, and the center would adopt and would apply the identical list procedure to enhance party autonomy. So a list of 6 candidates with their CV will be shared with the parties so that they can apply a strike and delete process, strike and rank process, I'm sorry. So they will set an order of preference and they will delete the names they do not want. So even in the appointment of the arbitrators and the presiding arbitrator or the sole arbitrator by the center, in case the 2 co-arbitrators fail to agree, party autonomy is enhanced. So it is a general approach and a general philosophy that is applied by the center.
Very clear. Thank you very much, Dr. Ismail. Very quickly, I have another, a line of inquiry. By looking into the expedited arbitration rules, I've noted that there are certain issues that we deal with in the context of arbitration that are not specifically addressed, in the rules. The reference to case management conference, for example, whether the parties would have the ability to amend or supplement their submissions, at a later stage in the process. As you said, part of the efficiency is that the parties have to cough it all up, at the very beginning, their entire claim, their entire defenses and what have you. Is there latitude for, amending or supplementing? Is there latitude for submitting counterclaims or set of claims at a later stage in the process? Some of these sort of practical issues that we encounter on a regular basis, they have not really been, addressed in the expedited proceeding. Does that mean that the fallback position would be, basically to revert back to, whatever is included in the standard rules of arbitration in the center? Because, as you quite aptly pointed out, the expedited arbitration rules are simply an annex, attached to the standard rules. And if there is any sort of gap or vacuum, in the expedited arbitration, basically the arbitrary tribunal would fall back on the standard rules. Are these issues sort of, addressed and should be sort of, adopted as set out, in the standard procedures? That is one area of, concern that I had. The other thing, if you can illuminate us, Dr. Ismail, on the current practice. You were telling me prior to the start of our webinar that there was an interesting case, recently that was administered under the sort of expedited arbitration rules, and it went through very quickly and very efficiently and apparently very successfully. I know that not a lot of time has elapsed between the introduction of the rules in 2024 and the current time, but if you can shed light on, current practice in this regard, how many cases have proceeded, under the expedited rules, and, your assessment of how successfully they were administered. Thank you.
Thank you very much. So these are very good questions. I think I should have mentioned this because this was a point that I have missed. Article 1, paragraph 2 of the Annex 3 that comprises the expedited arbitration rules provides that insofar as this Annex 3 does not provide otherwise, the standard CRCICA arbitration rules shall apply to an arbitration under the expedited rules. So this means that a case management conference would take place, and we call it a procedural meeting. So the procedural meeting should take place even under the expedited rules, because it helps expediting the process. It's not a waste of time.
Absolutely.
It has never been excluded, or there isn't a provision that provides otherwise. So that's why the provision applies. The right to file a counterclaim even during the second round that will follow the constitution of the arbitral tribunal, this will be based on the discretion of the arbitrator. Likewise, exactly, it will be based on the discretion of the arbitrator. So that's why, if as a respondent you have a counterclaim, I think you should from the beginning add it to your statement of defense. So you must have it from your first submission. So that's a good point. You can also, I think, even if during the second submission there is a counterclaim, perhaps the arbitrator will accept it, but of course will give the claimant the possibility to respond to it. But I think a counterclaim filed at the last submission defies the purpose of the expedited rules. So I think it's a good advice for the user. If the expedited rules are applied, the counterclaim should be filed from the beginning with the statement of defense that is filed after 30 days from receiving the request for arbitration. And so that's why we did not provide for a duration of 15 days. We provided for a duration of 30 days. Right. The statement of defense and the response to the notice of arbitration is due within 30 days from the receipt of the claimant notice of arbitration. This is to give time to the respondent to file its counterclaim, even if it intends to elaborate a little bit more in the next round of submission, but at least all the items, all the grounds for its counterclaim, I think should appear from the beginning. Well, when the case is very complex, that's a problem. I think the standard rules would be more suitable. If the case is not complex, so the counterclaim is not expected to be complex, then the expedited rules can be very suitable. To answer your second question, until now, so to receive a request to apply the expedited rules, the process has started because it's on an opt-in basis. The process has started in 2024. So when we were administrating our cases under the new rules in 2024, I have seen several times the claimant offering to the respondent to opt in, to abandon the standard proceedings and to opt into the expedited rules. But because the respondent usually does not want to make the claimant's life easier or easy, the respondent would usually reject the request. But now what I have heard is that there are many firms now that are inserting in the contracts the expedited rules of the CRCICA. You imagine if you have a small dispute, the amount in dispute is $50,000, so a very small dispute. You have a sole arbitrator, the fees of the sole arbitrator would be only $824. And the administrative fees of the center would be $750. So to give you the case of a legal counsel suing a client that has never paid, or a lease contract or whatever, a claim is small, really what you get is a very fast award that you will get in 6 months, and you will not pay a lot as arbitration costs. So I'm just giving you an example in numbers, and of course you can verify by going to our website and use the cost calculator. In addition, of course, to the $500, this is the registration fee that is due always. But the case that we have just registered very recently, and we have administered it in a very efficient manner and speedy manner, was a request to appoint an emergency arbitrator.
Interesting.
So the center has appointed an emergency arbitrator within 24 hours, although the rules provide that the emergency arbitrator should be appointed in 48 hours. But to achieve this goal, we usually reach several potential candidates to ask them to run a conflict check. The first who would clear conflict check confirm his or her availability will be appointed. And the emergency award or decision will be issued within 15 days, and the goal has been achieved without need to any extension from the center. And I promised the Kuwaiti community, hopefully, another session on the emergency arbitrators rules of the center, and perhaps to focus on other aspects of our rules, because I'm really keen that the Kuwaiti jurisdiction uses more the CRCICA. I think it's a missing opportunity of many users, and I don't want them truly, I'm saying this really, truly, and genuinely, not using CRCICA is a missed opportunity. And it is a choice that should be looked at more closely and try to test it. Whether you choose Egypt as the seat of arbitration, our courts are friendly vis-a-vis arbitration, and they very, very rarely set aside awards. Or even if you wish to choose the CRCICA rules and choose another seat as the seat of arbitration, like Paris, London, Geneva, the IFC, Singapore, whatever, we have an advisory committee composed of very experienced practitioners. The director of the center and the case managers, we have all enough exposure to different legal systems, so we are perfectly able to administer cases, even if these cases are not seated in Cairo, and regardless of the applicable law. Of course, this is the work of the arbitrators, but we are able to, while enhancing party autonomy, to suggest to the parties if we are requested to appoint high-class and high-profile arbitrators from all parts of the world. And as I have mentioned, we pay our arbitrators very well under our rules. It's 80% of what is paid to arbitrators under the ICC rules, and under the expedited rules, we pay the arbitrators 20% less, but still we are able to appoint very suitable arbitrators to decide upon these cases.
That is very clear, Dr. Ismail. Thank you very much for the comprehensive answer, and I obviously fully support your statement that not using CRCICA, in this part of the world would be indeed a missed opportunity, given the fact that we don't have many local alternatives, as you already know. With that said, and even though I do have, a number of other questions, but I need to control my urge to speak a lot, and I want to open it up for QAs from, other attendees. I'm not sure whether they do have the option of, getting in with a voice inquiry, or they're going to be sending, written questions. Whatever mode that would be available and would be preferable by them, would be happy to accommodate, any inquiries, questions, to Dr. Ismail. And scope of inquiries could be in relation to expedited arbitration rules, or otherwise in relation to the function, and the promising role of CRCICA as an alternative dispute resolution forum. So, anybody who's interested in raising any questions, we would very much be happy to entertain them now.
I already see 2 questions on the question and answer.
Please go ahead, Dr. Ismail.
So one question was, many thanks from Mr. Isam Mohsen. Many thanks. And could we summarize the reasons of the 2023 drop in the number of new cases? Well, of course, it was a drop, but the average amount in dispute was bigger. So the cases were relatively bigger compared to 2022, for example. The average amount in dispute was smaller, but we have registered much more cases. Well, 2023 was a period of economic crisis following the COVID. In Egypt, it was, we specifically, the world in general was suffering from the Russian-Ukraine war, and in Egypt, its economy in 2023 was severely suffering in 2023 and relatively in 2024. There was, because of this economic crisis at that time, which is still here, but the economic situation is relatively better. I think because of what we are encountering worldwide, there was this drop, And there is also part of the number of cases, you know, there is a kind of, part of it is has no reason, and part of it can be attributable to reasons. But I would say we have encountered the COVID, the Russian-Ukraine war, which has severely affected Egypt and the region, and the world in general, and also the regional crisis that we are going through. I think all this is affecting the economy in general and affecting the parties in general. And in 2024, by the way, there is a trend. All the major, even international centers, they have experienced in 2023 and 2024 a certain drop. Some of them has seen their caseload dropping. So, but I think the CRCICA has the merit of issuing statistics and informing about its caseload since 2012. And this was something that was not done by all the centers in the region. So I hope that this, but this year looks promising, but you know, we never know how it will end. So that's my answer to the first question. The second question was, can CRCICA decision to extend the proceedings be challenged if the claimant wants to benefit from the expedited proceedings? The decision, I don't think there is a party who would have the interest to challenge this decision, especially the claimant, because if the parties have agreed to the expedited proceedings, the decision must be issued within 6 months from the appointment of the sole arbitrator. And then the 6 months are not enough. The sole arbitrator needs 1 or more 2 months. It's not in the interest of anybody not to permit such extension, unless we have a respondent who does not have any hope to win the case and would try to challenge it. But to challenge it where? To the center? It's the center rules that provide so. To challenge it before courts, the courts would reject the challenge, because if the CRCICA extends the time limit, it is what the parties have agreed. The parties have agreed to give the CRCICA the power to extend the time limit. So I hope that this would have answered the question of Mr. Rami Shahata. The question of Mr. Mohammed Al-Shahabi. Dr. Ismail is the arbitrator in expedited arbitration. Are nominated by the parties, or the center will appoint them directly? Mr. Al-Sahabi from Sudan. The parties will be given 15 days to agree on the appointment of the sole arbitrator. If they fail, then the center will appoint. The center will have the 2 options, either to use the identical list procedure, and it's not a waste of time. I believe it's a very good practice, so that the parties are involved in the appointment of the sole arbitrator, or the center will directly appoint. It will depend. Another question from Ms. Aya El-Far. You mentioned that CRCICA enjoys immunity from legal action. Is there a trend towards legal action against institutions and arbitrators becoming less exceptional? Well, it is not, I cannot say it's a trend, but it happens from time to time. For example, in an institutional arbitration, the center has appointed an arbitrator on behalf of a respondent. The respondent has been given 30 days to appoint an arbitrator. And then the center gives the respondent another possibility to appoint its arbitrator. The respondent doesn't appoint its arbitrator. So the center appoints an arbitrator on behalf of the respondent. Then the respondent appears, although duly notified, given all the reasonable opportunities to appoint an arbitrator. And then the respondent is unhappy with the decision and start to sue CRCICA, requesting the court to appoint a tribunal, an arbitrator, or requesting damages from the center. Then in this case, or contesting the center's decisions, taken in challenges against arbitrators, for example. All this renders the center immune from these actions, or a party that has lost the case and sue the center instead of trying to set aside the award, because the award will not be set aside. So the party can embark into guerrilla tactics and start to sue the arbitrators unwarrantedly or sue the center, then the center will invoke its immunity, and the Cairo Court of Appeal has issued a decision that the center enjoys an immunity and should not be involved in legal proceedings, except if that party requests from the Secretary General of ALCO to remove the immunity. And in this case, the CRCICA can be sued. So it's not an absolute immunity, but you have to request from the Secretary General of ALCO, who is based in New Delhi, and it's not impossible to reach the Secretary General, to remove the immunity. This is in accordance with the headquarters agreement. CRCICA is not the only arbitration center that is immune, by the way. All the arbitration centers based in the common law jurisdiction, especially in the United States, the arbitration centers, they have a legal immunity against this type of lawsuits. So, and in the English Arbitration Act, there is an immunity for the arbitration centers as well from being sued by the parties. The resistance against the enforcement of the award or the setting aside proceedings against the award, this is the right forum to seek the intervention of the judiciary in post-arbitral proceedings, and not to systematically sue the arbitration centers. In the continental countries like France, the centers are not immune, so the ICC sometimes is sued. And I have heard Alexis Moore criticizing this type of lawsuits because usually they are unwarranted, and the ICC managed to win these cases that were lawsuits against the ICC. And they have a specific general counsel and law firms defending the ICC against these cases, which are usually unwarranted. Arbitrators also are sued, but there is a provision within the CRCICA rules for the limitation of liability of arbitrators, and the center as well. So if the arbitrator does not commit a deliberate or fraud or deliberate violation, such as a criminal offense or a fraud or a deliberate violation, the arbitrators would be immune, or at least under the civil law concept, they will be their liability would be limited, except in cases of fraud or gross negligence. So that is another question. Then we have the question of yes, the next one. Sorry. Yes, Mr. Tamer Abu Laila. My question about the expert determination. How can experienced, talented join CRCICA, and what is the criteria selection of them, especially in engineering? You will send the request to info@crcica.org with your CV, and we have a list of experts. So these lists of experts are either sent to the arbitrators or the parties when they wish to appoint an expert, whether a party-appointed expert or a tribunal-appointed expert. They are not binding to the parties or the tribunal. The tribunal can appoint an expert from outside this list, as well as the parties, but we are usually consulted and asked for them for these CVs that are on our list of experts. Also, expert determination as an ADR. This is a mechanism to appoint experts prior to resorting to arbitration. When there is a difference between the parties on a technical matter, so an expert would be appointed prior to resorting to arbitration, and the expert would issue an opinion that may permit the parties to solve their differences without need to go to arbitration. So CRCICA, at least concerning contracts enforced in Egypt, is frequently or occasionally at least chosen as an appointing authority for experts in expert determination. So that's why we are planning to issue specific rules on expert determination, and very few arbitral institutions have issued dispute board rules and expert determination rules. We have already done so for the dispute boards, and they are useful. And also now we are going to issue rules for expert determination as well. Mr. Raymond Hanna, with regard to the enforcement of the award from CRCICA, can it be enforced outside Egypt? Of course, yes. We have there are many arbitral awards issued under CRCICA rules, which have been enforced in France, in the US, in Germany, in many countries, in Arab countries, in many countries of the world, especially within the member state of the New York Convention, yes, and also the Riyadh Convention. So if you have a case against Libya, you have a case against Yemen, you have a case against Somalia, these Arab countries are not party to the New York Convention, but they are parties to the Riyadh Convention. So you can enforce also a CRCICA award under the Riyadh Convention. So if you have a dispute against a Libyan party, for example, or Sudan has joined the New York Convention, but Libya and Somalia and Yemen did not yet join the New York Convention. You can choose CRCICA and Cairo as a seat and be able to enforce the award based on the Riyadh Convention. Are there experts in the field of intellectual property? So a question from Judge Ismail Amrallah. I'm not sure, but certainly we do have. But the number of cases involving intellectual property, I have to say, under CRCICA rules is quite limited. Perhaps license agreements to use a pattern or license agreement to use a trademark. We have some franchise cases or franchise agreements cases, but certainly we would have one or two intellectual property experts, but I have to review the long list of experts. So that is for the questions that I have seen, the questions and answers. I think I have, there are 4 more open questions. I think I have answered all the questions so far.
Fantastic. Thank you very much, Dr. Ismail.
There is Mr. Ahmed Abdel Gayed. Sorry, there is Mr. Ahmed Abdel Gayed. How do CRCICA rules of confidentiality deal with multi-tier dispute resolution clauses, specifically with documents that can be beneficial with multiple proceedings, but at the same time being confidential? For example, med-ar clause. The answer to that is that in the mediation rules and in the dispute board rules, we also have a confidentiality provision that is exactly identical to the arbitration, the confidentiality provision in the CRCICA rules. And then we have a question on the place of maritime arbitration in CRCICA. We have administered few cases involving maritime disputes, and we know if there is a need to appoint an arbitrator who has an experience in maritime arbitration, we are able to find and to have these. There are some on our lists, and there are some that we can easily find. This will not be a problem at all.
Excellent. Thank you very much, Dr. Ismail. I take it that you have no other questions pending. I think we're going to give the participants maybe 1 or 2 minutes. We still have 10 minutes before the end of our webinar. So I think we're going to give the participants a couple of other minutes if they have any additional questions. In the meantime, just I've noted, Dr. Ismail, looking into the expedited rules, is that the tribunal, the arbitrator, sole arbitrator, commonly in expedited proceedings, would have the discretion to set aside, as you quite correctly pointed out, the disclosure or the document production exercise, after consultation with the parties, but regardless of any contestation by any of the parties. But that does not apply, to the concept of holding an oral hearing. When it comes to an oral hearing, if one party insists, on proceeding with an oral hearing, that would be the case. So there is a bit of a distinction here. Apparently, it was thought that, a hearing is probably essential if requested by one of the parties, to ensure fair play and due process, as opposed to dispensing with the requirement of document production, which is very much in the hands of the arbitrators. Is there any risk there, given that distinction, that one could argue that by being deprived of the opportunity of disclosure and document production, that somehow that would impugn the sort of due process nature of the process?
And I don't think so, because it's party autonomy at the end. The parties, it's on an opt-in basis. So if the party have opted in, the rules of evidence are not public policy rules. We have to, as you know, of course, so the rules of evidence are not public policy rules. So if the parties have opted in, and I think that's why this is the advantage of the opt-in approach.
Right.
No one is forced to accept that.
Exactly. No, absolutely correct. However, based on what you said, Dr. Ismail, the fact that respondents, being obviously very keen on not, proceeding with expedited proceedings, so far, the opt-in mechanism, has not been very successful in sort of, proceeding with expedited. I mean, is there any scope, if that continues to be the trend, to move away to the opt-out option used by the ICC?
It's very possible if after several years, and there is a demand from the users, certainly we will administer some of these proceedings. And from what the parties would tell us, and from the opinion of our users, if the users are of the opinion that at least for the disputes, for example, amounting to or that are below a certain threshold, we need to change to the opt-out procedures, I think we can, of course, consider doing it. It will not be for this year or next year, but when the rules will be amended. But at least I think we should be cautious, because by that time we would have gained experience in managing these proceedings, and we will see the pros and the cons. So I don't think it's wise to make the reforms gradually. I think it's wise. So the opt-in approach, even if it's perhaps we can discover later that it was not the best approach and that we have missed some opportunities, but I think it's still a wise approach. It's a calculated approach, and we will see, of course, but I expect that soon we will receive cases where in the very contract the expedited rules have been chosen. I believe that last year we did not promote them enough, but this year we are going to promote them more, because we have received a lot of requests from the parties that how can we apply them, and we received many questions on them. So I think the trend will change, and one day we will start receiving more of these cases.
That makes a lot of sense, Dr. Ismail. I guess for my side, I mean, you've done an excellent convincing job, of the benefits and the pros of proceeding with expedited arbitration proceedings. If we don't have any additional questions, and I'm afraid even if we do, we are almost running out of time. So maybe we have time for one more question. If you have anything pending, Dr. Ismail, at your side, if there's anything that you want to address in the next couple of minutes, otherwise, I think it's a wrap.
Thank you so much. Well, I have seen, I see one comment and two questions. But I would like to say that even if the parties are not convinced with the expedited rules, of course, they are welcome to choose the standard CRCICA proceedings, and they can agree on a time limit, by the way. So they can combine both, but not a very short time limit, because under the standard rules, sometimes we find contracts They provide for the standard rules, but a time limit to issue the award, a time limit of 1 month or 3 months to issue the award. And this is practically impossible. Yes, so I will answer now the last questions. Mr. Gamil Iskandar, thank you for this webinar. I have one question, and it's very confusing from my side. How to start the route to be certified arbitrator in Egypt, especially in engineering and construction field? I advise you to attend our course, our CIR membership course for 5 days, and you will get a membership at the CIR. I advise you to attend it. It will be during the second half of the year. I truly advise you to register your email on our mailing list. Once you see that you receive a mail, registered immediately in the CIR accreditation course that the CRCICA manages and delivers. Mr. Prakash.
Sorry.
Yes, Mr. Ahmed, you wanted to say something?
No, I want to second your recommendation of joining, the training, the CIR training at CRCICA. I would ask our associates, and junior lawyers to consider that. I think it provides very good and helpful training for those interested, in acting in the field of arbitration.
And with a very reasonable cost, by the way. And those who teach in this course, Professor Muhammad Abdul Rauf, Professor Muhammad Abdul Wahab. So you have great scholars and arbitration practitioners who deliver this course. And the assessment process that is done by Dr. Dalia. And I do participate also in the teaching of this course. So I think it's an opportunity not to be missed. And then you will get the membership of the Chartered Institute of Arbitrators. So I think and when we announce this course, it is filled and booked and sold very, very quickly. So my advice, register immediately and then start the payment process thereafter, but register very quickly. A question from Mr. Prakash Puthi Yadavan. Sorry if I'm not fluent in Indian or Pakistani language. So your question is, CRCICA is silent on the non-compliance of deadlines pertaining to the parties. It is to respect party autonomy because it's the tribunal who will decide if a deadline has not been complied with. Yes, there is Article 30 that provides that the statement of claim, for example, if not delivered on time, then there is a default. But it is up to the tribunal. It's the tribunal that decides what sanction to apply in case of missing a deadline. And if no party objects, then there is a presumption that the party has waived its right to object. This is under all arbitration laws and all arbitration rules. So in case of non-objection, there is a waiver. Aditya Prakash also. Hi, the ears are less expensive, but due to the deadlines, the lawyers will charge clients more. Please comment. I'm not a lawyer. I cannot speak on behalf of lawyers.
That's not a good way to end our discussions.
I will be back to private practice very soon.
Don't worry about it because that person happens to be at my office. I will provide him with a direct answer, Dr. Ismail. Don't worry about that part. I think with that said, with this question, I mean, we are coming to the last minute of the webinar, and we are keen on compliance with our time limits. I would like to take this last minute to thank my good friend and very, very accomplished scholar, Dr. Ismail Selim, on this excellent, very convincing, very well put together presentation. I, for one, very much convinced that CRCICA presents an excellent choice as a dispute resolution forum. I invite all of you to study that option seriously in terms of advising your clients and in terms of drafting your contracts, going forward. Dr. Ismail has indicated that he's keen on expanding and highlighting the role of CRCICA in the Kuwaiti market. We very much are here to support that effort. I tried my best to get an exclusive sort of role in this regard, but Dr. Ismail quite correctly going to expand the word, and quite rightfully, through other means within the Kuwaiti community. We very much support his efforts in this regard. We would love to see Dr. Ismail, personally in Kuwait, and we are in the process of arranging something for him to appear and to proceed with a conference, hopefully in the last quarter of this year. I think that would be very, very helpful indeed, and as a way of paying him farewell at the end of his tenure as a director of CRCICA. In the meantime, with the permission of Dr. Ismail, I think it would be a good idea if we have another webinar, say in September after the summer vacation or something, where we would be very much interested in sort of looking into any sort of trends, any sort of precedents that have been established in CRCICA's jurisprudence by looking into the various judgments that Dr. Ismail told us that they are available and published in various publications and what have you. So deciphering and determining the sort of trends established by CRCICA and its jurisprudence, I think that would be very, very helpful. And again, I think it's going to be a good guideline for us to determine the viability of CRCICA as a dispute resolution mechanism. With that said, I repeat my thanks to Dr. Ismail, who basically fought his cold throughout the process, and he came through in a brilliant manner. Thank you very much, Dr. Ismail. Thank you for all the attendees, and I leave the last word for Dr. Ismail.
No, I can't thank you enough, Mr. Ahmed Barakat, and for the moderation and for hosting this event, and with more than 100 participants and more than 300 registrations. So I'm very grateful to you and for dedicating your valuable time. You are a very prominent lawyer. Your time is very valuable, and you have dedicated this time for me. I've exceeded the time. It's a 2 hours and a half webinar, but really I am very, very grateful to ASAR law firm, and I'm always happy for you when I see your notable law firm winning prize after prize, and it is very well merited. And I hope to see you in Kuwait. I hope to see you in Egypt. I hope that the audience, including those who are working and concluding contracts in Kuwait, that they consider this offer, and I confirm that they will never regret it. To the contrary, it is an opportunity not to be missed. It is an option that should be considered among, of course, other options. I do not pretend that we are the exclusive arbitration center or efficient arbitration center, but I think we are one of the best worldwide. This is what the reports mention. This is what the arbitrators and the parties council mention, and it is a center that merits a closer look and is very inspiring within the MENA region and Africa. Thank you very much for your kind attention. Thanks to all the participants. Thanks to my team at CRCICA as well, who has cooperated with ASAR team in order to make this webinar a success. Thank you so much.
Very much.
Hope to see you in Egypt and hope to see you in Kuwait in person.
Thank you, sir. Very kind of you, and you're absolutely correct. I would like to thank CRCICA's support team and technical team for their excellent contribution. I also would like to thank my partner, Adnan Gafar, my IT manager, my HR manager, Rina D'Souza, our new intern, Aditya, for all their contribution, to the success of that webinar. And we're looking forward to more and more. All the best, Dr. Ismail.
Thank you so much.
Thank you. Thank you, sir.
Thank you.
Take good care.